check 1 2 3 4. Hello, testing 1 2 3. Hello, check. Hello. Yeah.
राहुल सर, राहुल सर, सर ऊपर आइए। तो मेल आ जाएंगे।
अरे संजय जोड़ी आगे मेरा दोस्त।
उसको मैं डाल देंगे नहीं अगर वो यहाँ है तो खुलेगा अल्लाह में जगह करते दादी जब वो जा चुके होंगे ना तब लाइटिंग और लैंप भी होगा ना अपना लैंप कर देते हैं नहीं वो हमने सब कर दिया मैं ये कह रहा था साइड में कर दिया हमने उसको वो वैसे नहीं पेट्रोल टाइप का लकड़ी का नहीं फूल तो उसने लगा दिए हाँ हम नहीं लेके थे अभी हम नहीं लेके तो ये मतलब कारपेंटर में सोचा था अगर लकड़ी का पेड़ उसके ऊपर रख देते
से मिलकर लेकर आ जाओ यार क्लासिक को। रखिए ना जी, हाँ रखो। बुलाइए।
आपका फोन ट्राई कर रहा था।
अरे मेरा स्विच ऑफ हो गया। ठीक है जी। I request Mr. Vikas Singh, President SCBA, and Sir को बिल्कुल आप। I request Mr. Vikas Singh, President SCBA, and Mr. Rahul Kaushik, Vice President SCBA, to kindly escort Honorable Mr. Justice B.R. Gavai, Chief Justice of India, along with Honorable Mr. Justice Surya, Judge Supreme Court of India, to the dais. Mediation, all people have discussions. It is my privilege to welcome you all to this inaugural SCBA lecture series. I request Mr. Sushil Kumar Tomar, Joint Treasurer, to come forward and present bouquet of flowers and planter to Honorable Mr. Justice B.R. Gavai, Chief Justice of India. I request Mr. Mukesh Kumar, Member Executive SCBA, to present a planter to Honorable Mr. Justice Surya, Judge Supreme Court of India. It is indeed a matter of pride for all of us to share the historic developments and new initiatives taken in the field of legal aid and mediation under the leadership of Honorable Mr. Justice Surya, Judge Supreme Court of India and Chairman NALSA, and under the aegis of Honorable the Chief Justice of India, Justice Bhushan Ramkrishna Gavai. I was locked in jail, not for days, not for months, but for years. My only crime, poverty. No lawyer, no money, no hope. But the Supreme Court said, speedy trial is my right. Free legal aid is my right. These words echo the story of Husnaira Khatun, whose case transformed the Indian legal system. This judgment of the Supreme Court gave birth to an institutional system of justice for the poor. Today, through NALSA, under the leadership of Honorable Mr. Justice Surya, in the last 4 months alone, we have witnessed remarkable development in the Supreme Court. A total of 4,584 cases came from all across the country from different jails seeking legal aid, out of which 2,600 matters are filed by the advocate on record and advocates in 3 months. It is a record made in the history of the Supreme Court. A new legal aid panel has been constituted along with an assisting council. Over 700 members of SCBA and SCORA are now part of the Supreme Court legal aid panel. More than 1,000 members of the SCBA and SCORA have successfully undergone mediation training under NCPC. These numbers speak for themselves. This is a historic development and a matter of collective pride for all of us. Therefore, to mark this achievement, we have chosen the topic of today's lecture, Justice for All, Legal Aid and Mediation, Role of the Bar and the Bench. Now I request Ms. Andita Pujari, Senior Member Executive, SCBA, to give her introductory remarks.
Namaskar everyone. Honorable the Chief Justice of India, Justice B.R. Gavai, Honorable Justice Surya, Mr. Vikas Singh, President SCBA, Mr. Rahul Kaushik, Vice President, Pragya Baghel, Secretary SCBA, all office bearers of SCBA, members of the Executive Committee, including the members of special emphasis on the Subcommittee on Professional Development, Training for Junior Lawyers, which include Mukesh ji, Gaurav ji, Manish Mohan ji, Ashish ji, and Rachna, respected seniors, colleagues, and friends. It's truly a privilege and a joy to give introductory remarks in the inaugural session of the Supreme Court Bar Association lecture series. Let me begin by quoting Justice Ginsburg. Real change, enduring change happens one step at a time. Inspired by these words, the SCBA has taken one such step today by introducing this lecture series. It may seem like a modest beginning, but it is born of a greater vision to strengthen the core of the bar and to create a platform where we can grow together as a community. This initiative is not meant to be yet another set of formal lectures. Our aim is something profound. We want to build a bridge between doctrines and practice, between the wisdom of experience and the energy of new perspectives. We want to create a space where questions are welcome, lessons are freely shared, and there is a continuous flow of knowledge. In other words, this lecture series is about conversations between the judges, the lawyers, seniors, and junior members of the bar, mentors and mentees. Conversations about what really works in practice, about where we all fall short, about how we improve. Here, we'll not just talk about arguing a case or how to advise a client. This lecture series is designed for reflection on experiences. Think of this lecture series as both as a forum as well as a forge. A forum where generations of lawyers and judges can speak to one another openly and forge new practices, reinforce fundamental ethics, and enduring partnerships. We take the bar's tradition of mentorship to new height through this series. We are especially fortunate to begin this journey in the presence of Honorable the Chief Justice, Justice B.R. Gavai, and honor to have Justice Surya Kant with us on this occasion. As the topic of today's lecture is Justice for All, Legal Aid and Mediation, the collaborative role of bar and bench. It is not just an academic theme, it is a mission. It speaks of the responsibility we share as members of the bar to ensure that justice is not confined to abstract ideals, but touches the lived realities of ordinary people, which Pragya was just referring to. We have seen significant steps in this direction. The Supreme Court Legal Services Committee, NALSA, MCPC, which she was just referring to, they're all putting in their contribution in this movement. And these efforts remind us of what is possible when the bar and the bench work together. Today's lecture series and the beginning of it is only a bit in that movement that NALSA, Supreme Court, and everybody else is working towards together. It's our way of expressing our shared responsibility. Thank you so much.
Thank you, ma'am. I request Mr. Rahul Kaushik, Vice President SCBA, to kindly deliver the welcome address on this occasion.
It is both a privilege and an honor to welcome Honorable Mr. Justice B.R. Gavai, Chief Justice of India, Honorable Mr. Justice Surya Kant, Judge Supreme Court and Executive Chairman NALSA and Chairman Mediation and Conciliation Project Committee, Judges of the Supreme Court, my colleagues at the bar. On behalf of the Supreme Court Bar Association, extend my warmest greetings and a deep sense of gratitude to all of you gathered here today for the inaugural lecture of the lecture series. Mediation legal aid is something which is very close both to Justice Gavai and Justice Surya Kant, as recently a campaign called Mediation for the Nation was launched in July, which was a 90-day-long mediation campaign conceptualized by NALSA and MCPC to tackle pending cases from taluka courts to high courts. When the framers of the Constitution conceived of India as a sovereign democratic republic, they envisaged a nation where justice would not remain the preserve of the wealthy or the influential, but would be accessible to every citizen regardless of class, caste, gender, or financial standing. The preamble of our Constitution speaks of justice, social, economic, and political as the first promise of the Republic. Article 39A gives life to that vision by directing the state to ensure free legal aid so that opportunities for securing justice are not denied to any citizen. Legal aid ensures that the principle of equality before law under Article 14 is not an empty promise but a practical reality. It ensures that fundamental rights can be claimed by the weak as much by the strong. It reminds us that courts are not meant only for those who can afford lawyers, but equally for those who cannot. At the same time, mediation stands as a human, efficient, and a forward-looking path to justice. In an overburdened judicial system, mediation is not merely an alternative, it is essential. It brings speed, reduces hostility, and creates solutions that endure. At first glance, legal aid and mediation may appear to be separate concepts, one ensuring representation for the poor, other providing an alternative forum for resolution, but in truth, they are deeply connected. Together, they ensure that justice is actually delivered. Between 2016 and early 25, as many as 7,57,173 cases were resolved through mediation. That's a big number. Justice Gavai in his speech recently emphasized that mediation must move from being an afterthought to becoming an instinctive part of how the country resolves conflicts. When we speak of legal aid and mediation, we cannot have a better person here for the lecture than Honorable Mr. Justice Surya Kant, whose judicial philosophy and public engagements have consistently advanced these very ideals. Today, as he delivers the keynote lecture, it is worthwhile to reflect upon his vision and contribution and to understand how his ideas strengthen the theme before us. His work has reflected a deep empathy for the marginalized and a constant effort to bridge the gap between law and society. In the recent Justice R.C. Lahoti Memorial Lecture, he observed that technology has the potential to bring legal services to the very doorstep of the common citizen. Yet he cautioned that while machines may provide access to information, only human beings can provide empathy. The legal system therefore must embrace technology without losing compassion. He emphasized that law must speak every tongue of this diverse nation. By advocating multilingual legal aid through interactive application regional languages, he has reminded us that rights must not be lost in translation. As Executive Chairman of NALSA, he has promoted Lok Adalats, strengthened legal aid clinics, and encouraged awareness campaign, ensuring that justice travels beyond courtroom into villages, communities, and everyday lives. Equally, he has been a strong proponent of mediation. He believes that mediation is just not an alternative to litigation, but often a superior method of resolving disputes because it fosters harmony rather than hostility. Through this contribution, Justice Surya Kant has shown us that legal is not only a statutory obligation, but a moral imperative. Mediation is not merely an option, but a necessity for the future of justice delivery. Recently, Justice Surya Kant, as Executive Chairman NALSA, launched a scheme called as Veer Parivar Sahayata Yojana 2025, which was first of its kind to provide free legal assistance to soldiers and their families, and said during its launch, it is a fulfillment of a constitutional duty. In the end, the bench has the solemn task of ensuring that law does not remain rigid, but is infused with equity and fairness. The bar carries the responsibility of ensuring that no litigant walks alone, that no citizen is denied representation, and justice is accessible, and that no citizen is denied representation and justice is accessible in practice, just not in theory. Thank you.
Thank you, Rahul. Now I request Mr. Vikas Singh, President, SCBA, to kindly address the present gathering.
Honorable Justice Bhushan Gavai, the Chief Justice of India, Honorable Justice Surya Kant, Judge Supreme Court, Honorable Judges of Supreme Court present here today, Rahul Kaushik and Pragya Baghel, our Vice President and Secretary of the Bar, Vipin Nair, President of SCORA, Executive Committee of SCORA, Executive Committee of SCBA, the eminent lawyers and senior members of the bar present today in the audience. Today's subject actually is a very interesting subject in many ways. The subject is justice for all, legal aid, mediation, and collaborative role of bar and bench. when we talk of justice for all, according to me, and mediation go hand in hand, because it is only in the mediation process that there are no losers. And when there are no losers, then there is justice for both sides. In a litigation process, if there's somebody who wins the litigation, it may ultimately culminate in a finality of the litigation, but there is one side which feels that it has not got justice. Whereas in mediation, both sides feel that they have got justice. So justice for all, in my view, is actually something embedded with the concept of mediation. Legal aid in this country has, of course, been now quite well established and institutionalized, and of course there is still a lot to do. But every young budding lawyer, when he asks me that what is the best way to establish myself or to get better in the profession, I always tell them that you can always do legal aid work. Even if you can't do institutional legal aid work, you can definitely help people around by doing legal aid in your personal capacity, and that definitely will give you a good exposure, because unfortunately in our profession, unlike the medical profession, there is no internship. And this legal aid can be a very good way to give back to the society, to feel that doing something good for the system, and also learning in the process. Collaborative role of bar and bench, in my humble view, is actually the core of this debate, because when you talk of the collaborative role of bar and bench, then whenever a problem comes to you, or whenever there is a litigation coming in front of you, the bar and bench both should always try to first think whether this matter can be settled or not. And if that effort is there in every matter that comes before the bar and the bench, I'm sure a large number of matters will get resolved at the very first instance, because experience is that as litigation goes further, as affidavits are exchanged, bitterness between the parties increases, because affidavits are drafted in such a manner, many a times we see that even wrong facts are pleaded just to show as if how harmed my client is, which results in bitterness on the other side. And the more the litigation progresses, the more the bitterness increases and the less the chance of mediation. So I think if the bar and bench both play a role in the mediation and this legal aid process, of course there the bar will have to play a major role, then this can actually be a big opener for this subject. Today, we are actually grappling with, we had 10 years back, we had 3 crore and 6 lakhs cases in the country. Today, we have 5 crore 36 lakhs in the country. And when I give this number, this is for all the district courts and high courts and Supreme Court. Now, 2 crore 30 lakh cases have been added in the last 10 years. And according to me, and I compliment Justice Surya for this, for taking this very great initiative of pushing mediation. He has been very firm of this view. He has always been telling even otherwise that we will ensure that this whole process becomes a success. That if this mediation succeeds in this country, it will drastically, overnight, reduce the pendency of litigation in this country, and which will be a huge thing, because of the pendency of these cases, the justice delivery system itself is getting clogged, and that is really a big, I would say, a drawback in our system so far. So I think mediation is one way which can unclog the system and reduce the pendency and ensure that people of this country get justice. Thank you.
Thank you, sir. Now it's my proud privilege to invite Honorable the Chief Justice of India to deliver the inaugural address.
My esteemed senior colleague, Honorable Justice Surya, who is going to address us on the topic of justice for all, legal aid and mediation, the collaborative role of the bar and bench, my esteemed colleagues present in the audience, Shri Vikas Singh, President Supreme Court Bar Association, Shri Rahul Kaushik, Vice President Supreme Court Bar Association, Ms. Pragya Baghel, the Secretary of the Supreme Court Bar Association, all other office bearers of the Supreme Court Bar Association, the senior members of the bar, and my lawyer friends, as well as the students from the final year of Amity Law School who are present in large number. Dear friends, it's indeed a privilege to be present at the inaugural SCBA lecture series. At the outset, I must congratulate Shri Vikas Singh and all other colleagues for coming up with the idea of the lecture series. As a matter of fact, when I was at Nagpur and Justice Bobde was also there, so we had started a study circle wherein every fortnight there used to be lectures, and everybody, including the lawyers, they used to interact with everybody, and so it helped us enrich our knowledge of law. So therefore, I'm sure that this initiative by the Supreme Court Bar Association will help everyone, and specifically the young members of the bar, because we always say that in the legal profession, the learning is a continuous process. So even as judges, we are still in the process of learning every day. And I'm sure that this exercise will certainly help all the members of the bar, and particularly the young members of the bar. The SCBA has long been a pillar for the betterment of lawyers practicing before the Supreme Court, advocating for their professional development, ethical standards, and welfare. Every week, I get some mandamus from Mr. Vikas Singh, and today also I received a mandamus in the morning that you you ask the gate number 1 to be opened at least 2 hours before the function, and I can't afford to deny his mandamus. Every year every week, either Pragnya or Rahul, somebody is there in the chamber in the lunch recess with some suggestions and concerns concerning the member of the bar. There are various issues regarding the professional practice, such as case listing, infrastructure, and procedural reforms, and also the broader initiatives, including welfare initiatives, training programs, and measures to enhance access to justice. I must therefore congratulate the SCBA in being vigilant towards the issues faced by the members of the bar and bringing it to the notice of the concern. The consistent engagement of the SCBA demonstrated its active and constructive role in shaping the legal ecosystem, reflecting a commitment not merely to the interests of its members, but also to the promotion of efficiency, fairness, and excellence within the judiciary as a whole. Today's lecture marks a significant step in fostering dialogue, reflection, and collaboration between the bar and the bench. The theme of today's lecture, Justice for All, Legal Aid, and Mediation, the collaborative role of the bar and the bench, could not be more timely or more essential. Our Constitution enshrines the promise of justice for every citizen. Yet in practical terms, the path to justice can often be long, complex, and fraught with obstacles. For many, especially those from marginalized and vulnerable communities, the journey to a fair hearing is hindered by social, economic, and geographical barriers. Courts may be distant, proceedings intimidating, and access to competent legal representation limited. In such a context, justice risks remaining an abstract ideal rather than a lived reality. The collaborative role of the bar and the bench is a theme that bears emphasis. Lawyers are not just representatives of individual clients, they are custodians of justice, and they serve as the link between the citizens and the court. Judges, in turn, are entrusted with the solemn duty to ensure fairness, equity, and due process. When they operate in partnership, guided by principles of professionalism, integrity, and empathy, justice can reach even the remotest and undeserved corners of our country. I often say that judges and lawyers are like the two wheels of a golden chariot. Alone, neither can move forward with the same purpose or speed. It is only in their harmony, in their coordinated effort, the chariot of justice advances smoothly. Legal aid schemes have been a cornerstone of this collaborative effort. From the earliest days of our legal system, the recognition that justice must be accessible not only to those who can afford it has been central. Legal aid ensures that those who are economically disadvantaged or socially marginalized are not denied representation, guidance, or support in navigating the complexities of our legal system. However, many eligible citizens are unaware of their rights under their schemes. Here lies the role of both the bar and the bench to simplify, to guide, and to create an environment where justice is approachable, understandable, and equitable. Equally important is the role of mediation and alternative dispute resolution. In a country with rapidly expanding population and an over-increasing caseload, traditional litigation alone cannot bear the burden. Mediation offers a path that is conciliatory rather than adversarial, restorative rather than punitive. It encourages parties to seek solutions collaboratively, preserving relationships, saving resources, and ensuring timeliness in dispute resolution. Yet its success depends on the good faith, expertise, and guidance of both lawyers and judges. In particular, I would encourage senior advocates to actively guide the parties appearing before them to consider settling their disputes through mediation. Their experience, credibility, and understanding of the law place them in a unique position to help parties appreciate the benefits of this approach, and not only in terms of time and cost saving, but also in preserving relationships and promoting mutually acceptable solutions. In contrast, both court litigation and arbitration often involve lengthy procedures, complex formalities, and significant financial expenditure. Lawyers who have achieved financial success and recognition in their profession also have a responsibility to devote a portion of their time to pro bono work, not merely as a charitable act, but as a matter of principle and professional practice. Their knowledge, skill, and experience should not remain confined to those who can afford legal services, but should reach every corner of our country, touching the lives of the most marginalized and vulnerable citizens. Thus, the legal aid and mediation together bridge the gap between constitutional theory and societal practice. Legal aid and mediation are instruments through which we translate the ideals of our Constitution into lived realities for the people. In this context, lectures such as today's are not merely academic exercises. They serve as catalysts for reflection, discussion, and reform. They remind us of our ethical responsibilities and constitutional duties, and the transformative potential of collaboration. They inspire young lawyers to see beyond the immediate advocacy and to recognize their role in shaping a fairer, more inclusive system. They remind judges that empathy, outreach, and accessibility are not optional virtues, but essential components of judicial service. Let me also emphasize the symbolic importance of this lecture series. In a legal ecosystem often constrained by deadlines, filings, and procedural formalities, taking a pause to reflect collectively on the broader mission of justice is invaluable. It is in these moments of engagement between bench and bar, between thought and practice, that meaningful reforms begin. I am glad that SCBA has invited my senior colleague, Justice Surya, to deliver this lecture. Justice Surya has over the years consistently exemplified the constitutional vision. Through his judgments, writings, and engagements with both the legal fraternity and the citizenry, he has highlighted the importance of access to justice, the ethical responsibility of lawyers, and the need for the bench and bar to work in unison to reduce barriers of justice. As Executive Chairman NALSA, he has been spearheading the evolving policies on legal aid and alternate dispute resolutions. I hope that today's lecture inspires each of us to reflect on some fundamental questions. How can we, in our respective roles, ensure that justice is not only done, but is seen to be done? How can we leverage legal aid more effectively? How can mediation and alternative dispute resolution be integrated seamlessly into the mainstream without compromising fairness and accessibility? I'm sure that with the rich experience of my learned brother, Justice Surya Kant, the young lawyers, the students, and all the members would be enriched. I was told by Mr. Vikas Singh that the lecture series would be monthly. I'm really happy that all of us will get an opportunity to be enlightened on a variety of subjects by the judges of this court, by the retired judges of this court, and senior lawyers. I'm grateful to Mr. Vikas Singh, the office bearers, and everyone for giving me this opportunity to inaugurate the lecture series, which will be very, very valuable for all of us. Thank you very much.
Thank you, sir. Can I request the young members of the bar to give seat to the lady members of the bar? Can I request the interns or any advocates, please give seats to the lady members of the bar. I request the Honorable Chief Justice of India and Justice Surya Kant to start the SCBA lecture series by lighting of lamp and formally declare that the lecture series open. Okay, thank you.
With this, I declare the SCBA lecture series inaugurated, and Justice Surya Kant will deliver the first lecture. Thank you very much.
We express our deepest gratitude to the Honorable the Chief Justice of India for inaugurating the series and sharing his vision. Due to pressing commitment, the Honorable Chief Justice of India will now take leave. Yes, we are truly grateful for his gracious presence, Your Lordship. Honorable Mr. Justice Surya Kant, Judge Supreme Court of India, also serves as the Executive Chairman of the National Legal Service Authority. Honorable Mr. Justice Surya Kant's efforts in both legal aid and mediation comes from his deep conviction that justice is strongest when it reaches the weakest. As I said earlier, in the last 4 months alone, we have witnessed remarkable development in the Supreme Court under your leadership, Your Lordship. He recently launched the Veer Parivar Sahayata Yojana 2025, as informed by Mr. Rahul Kaushik, a dedicated initiative to provide free legal aid to defense personnel, veterans, and their families. Under his guidance, interactive legal aid app will be launched soon in different local language. For example, helping a migrant laborer in Bhojpuri, he can ask, "Ka adhikar ba hamar, jab malik paisa na de?" The app will answer in local language. So I request The Honorable Mr. Justice Suryakant has also been strong advocate for mediation as a parallel pillar of justice. In 2025, he guided the 20-day nationwide Mediation for the Nation campaign conducted jointly by NALSA and the Mediation and Conciliation Project Committee under the guidance of Chief Justice B.R. Gavai. I once again welcome you and invite our distinguished speaker, Justice Suryakant ji, to share his valuable insight and deliver inaugural lecture.
Justice Bhushan Ramkrishna Gavai, Honorable the Chief Justice of India, in absentia because he had to leave for some important administrative assignments. My esteemed colleagues from the Supreme Court, who are kind enough to grace this occasion, Shri Vikas Singh, President Supreme Court Bar Association, Shri Rahul Kaushik, Vice President, Ms. Pragya Bagail, Honorary Secretary of the Supreme Court Bar Association, other office bearers of the Supreme Court Bar Association, Mr. Vipin Nair, and other office bearers of the SCORA, who are also present here. I can see a very eminently senior advocates from the Supreme Court Bar Association who are also present here, distinguished members of the Supreme Court Bar Association. There is a team of, rather a huge team of dedicated mediators who have been carrying our flag high in the Supreme Court Mediation Center as well as in Delhi courts, who are also present among us. Officers of the Supreme Court establishment. I am told that some law students also are present. So very good evening to my dear law students as well. I am deeply honored to speak you today in this inaugural session of the lecture series that has been initiated by the Supreme Court Bar Association. Pardon me, I was down with mild viral fever from last 4 or 5 days, and I was wondering whether I will be able to speak with my full energy and the emotions which I thought that I must input when I speak you on the legal aid and mediation and the role of the bar in making this event successful. But then I thought that it's the beginning of the series, and therefore I must not cause any impediment, and regardless of the health issues, I must go and share my views. The amount of your overwhelming presence, in fact, really emboldened me, and I must forget that whatever slightest health issues were there, those should not be the relevant consideration. I must congratulate Mr. Vikas Singh and the entire team for taking this initiative of lecture series. This is extremely important not only to bring the bar and bench together on a common platform, it's also important to exchange the best of the ideas and best practices. I foresee a day not far away when the judges will be sitting on this side and prominent members of the bar will be speaking on this lecture. And we would love to have him on that occasion also. The today's topic, Justice for All, Legal Aid and Mediation, the collaborative role of the bar and bench, is extremely significant as it extends beyond legal theory to touch the daily reality of millions who turn to our courts seeking both legal remedy and the dignity that justice promised them. They arrive here carrying legal issues, certainly, but more importantly, they carry the fundamental faith that justice will serve them as well. Yet, what troubles me profoundly, and which Mr. Vikas Singh also in his brief note addressed, is a paradox we have unwittingly created. In this world's largest democracy, access to justice has been till recent times a privilege of prosperity. When legal fee eclipse the monthly income, when procedures demand literacy that millions lack, when court rooms or court houses and their corridors intimidate more than the welcome, that is the stark reality sometimes and openly we face. We have built temples of justice with doors too narrow for the very people they are meant to serve. The scales of justice cannot balance when only one side can afford to place their grievances upon them. A few days back, or maybe about 1 or 2 weeks back, I reacted in court when a battery of senior advocates appeared only in one matter and wanted a petition to be entertained directly in Supreme Court. It was nothing against the honorable members of the bar. It was not against, we can never thought of against even litigant also, we have to do justice as per law. But I reacted. And that was reacted, when I reacted, it was definitely coming from my heart. I said that, are we going to turn the Supreme Court only for a selected litigants and selected lawyers? Probably that is not the idea, because when we talk of temple of justice, we are primarily and most prominently talking about those whom, as I said, we find that they are in dire need of justice. And therefore, the scale of justice need to have a balancing approach for all and one, irrespective of their status in profession or as a litigant. Here before me, I must fairly concede, when the prominent senior lawyers, some of whom are present here, when they argue the matters, I always go in introspection and think and feel myself as a student of law, because the eminence with which they argue, the knowledge they have, the way they articulate their points, the way they take us to the constitutionalism and the constitutional philosophy, that is something remarkable, and for that I must compliment the members of the bar. And not only the senior leading lawyers here, this bar has a great hope for the future, because the young members of the bar also, there are very extraordinarily competent young people are coming with complete passion and dedication to the profession, and therefore the future of the bar is as bright as the present. Now, in the context of the legal aid and the constitutional provisions, which Mr. Rahul Kaushik also referred to, Article 39A, this is precisely where the legal aid becomes not just important, but essential to our democracy. Legal aid is not, as all of you know, a mere legal charity. It's a constitutional oxygen, I say, essential for democracy's survival. When we speak of legal aid, we speak of India's promise to herself. In this ancient land of diverse tongues and traditions, the law must speak every language, reach every village, and answer every call for justice. Please remember what Dr. Rajendra Prasad, the first president of India, reminded us when he said, and I quote, "Justice, liberty, and equality must be more than the words they should reflect in every Indian's life." And that is what should be the motto of any justice delivery system. This vision of Dr. Rajendra Prasad manifests daily across our nation when you find a tribal woman from Odisha who secures her forest rights, a migrant worker in Delhi who recovers his unpaid wages, a domestic violence survivor in Kerala who finds safety and dignity. Why? Because legal aid transforms these constitutional covenants from mere dreams into lived realities, dismantling the invisible barriers of cost and complexity that keep justice out of reach for millions. And very recent time I met a district judge. He was known to me when he was a young judicial officer when he joined from the bar as additional district judge. He shared a very small incident, but that really touched my heart. He said an old man, senior citizen, cheated by a property dealer who took his life savings, approached their legal aid cell. The old man said, I can't afford a lawyer or understand even the complexities of the legal procedure. The district judge said that, let me find out that how, because of you are talking of investment of so much money in a property dealer, let me see how would you qualify for legal aid in terms of section eligibility conditions given in section 12. Because if you are having a particular kind of income, then probably unless you are below that cap, you may not be qualified. So the old man got afraid that I may be even not eligible even for legal aid. So what he said, I just want what is fair. Sir, I have worked honestly to earn the honestly earned money that I have lost. Am I not entitled to legal aid even for that? The district judge, of course, a man with compassion, he wrote to the authority and ultimately he eventually provided the legal aid to him. I believe in the consumer complaint, he succeeded. And some money principal amount was recovered from him. But see, there will be millions of such people who might not be technically entitled to legal aid in terms of the statutory embargo, but indeed they still need the legal aid. So the spectrum of legal aid, the concept of legal aid, the contours of the legal aid are also need to be widened, twisted, elaborated, and maybe like a judicial interpretation given such a wider meaning that the entire community of justice seekers who by virtue of any family circumstances or any reasons who are unable to approach the court of law or they are feeling handicapped, let us provide them a green light express way of legal aid. I believe this developing a successful legal aid framework across a country as diverse as ours is only possible through active collaboration and knowledge sharing between the bar and the bench. The bench has, through landmark decisions, giving a live meaning to Article 39A, whether you talk of Hoskar judgment or later on in Khatri judgment, legal aid has been read as a fundamental right referable to Article 21. Now, having held as a fundamental right or a part of the right to live with dignity, the question that ultimately arises, the issue which I was just half a minute before I was raising, that how to formulate that framework that under which this fundamental right can be guaranteed to all. And therefore the role of the bar, I am coming to that, becomes very significant, because if we have given a meaning to Article 39A referable to Article 21, that means that Article 39A, a directive principle, is now to be read as part of Article 21, a fundamental right. Then how to translate it into reality? So beyond adjudication, the judiciary's administrative role has also proven equally vital in democratizing the judicial remedies. I think Rahul referred to the very recent Yojana which under the NALSA banner we have launched, that is Veer Parivar Sahayata Yojana. That was one of my, I will not say my dream, but it was, I had a very strong urge for it, that the moment a chance is given to me, I will reach out to the members of the defense personnel, the paramilitary forces, and will try to address their issues. And in Srinagar, when we launched, I only talked to them, they were in large scale, they were present there. The purpose of this scheme is that when your family is in legal distress, when your senior citizen parents are in legal distress, when your children are not getting admission in a school, when your neighbors, I use three words there, Parivar, Padosi, or Praya. There can be a litigation against the defense personnel within the family. There are so many disputes sometimes that happen. पड़ोसी आपके खिलाफ मुकदमा डाल सकता है, बोलेगा आपने हमारी जमीन पे एनक्रोच कर लिया, या वाटर को लेकर के मेरा राइट ही है, आपका राइट नहीं है, या किसी खेत के पार्टीशन को लेकर के हो सकता है, और एक प्राय कोई स्ट्रेंजर भी केस डाल सकता है. So we said that we will take care of your litigation, whether it is by your family, whether it is by neighbor or by a stranger. So all three P, Parivar, Padosi and Praya, we will take care of all three. You take care of the nation, the boundaries and the borders as you have been bravely looking after. Your legal rights, we will take care of that. I can share with you the response throughout the country is remarkable. The defense personnel, they never thought of that somebody will, that NALSA as a platform will come and provide them this kind of assistance. We have already established our legal aid clinic in the state Rajya boards and the Jila Rajya boards, and our officers have started coordinating, and the legal aid at the ground level has been provided to them. Now, in the context the bar rules comes, we may deliver judgment on judicial side. On the NALSA platform, we launch a scheme also. But I personally feel that everything will be effectively not so meaningful unless there is a very dedicated cooperation of the members of the bar. The reason is very simple. You, the member of the bar, are the soul of any vision that may be required to be translated into reality for the purpose of legal aid or the justice delivery system. When I see someone from a marginal community finally getting justice, I know there is an advocate who chose to fight for him. When I witness a constitutional right coming alive in a courtroom, I see your hands giving alive in a courtroom, and it is your hands ultimately which gives life to those words. Ultimately, who fights for that person? Only one of you. Your commitment to legal aid is not born from rules or regulations. It comes from something far deeper. It comes from the moment you first saw a person broken by a system they could not navigate, and you decided to be their voice. This spirit is not new. It's in fact in profession's DNA. A legal professional, he can never sit silent when he will see that somebody's right is being violated. Let's remember, more than maybe now it's a century ago, Bombay Bar, they created the Bombay Legal Society, making a promise to the forgotten and voiceless. Mr. Singh will be in a better position to explain to us about it, but I believe that they formed a Bombay Legal Society, and that was promised to the forgotten and voiceless people. That fire spread nationwide, lighting up legal aid movement from Kerala to Kashmir. Every breakthrough, my friends, started with someone like you saying, "Not on my watch, that's not legal history, that's your legacy calling out to you." Building upon this legacy, the bar came in an entirely new avatar through public interest litigation. In 1979, Kapila Hingurani ji, a senior member of this bar, when she read about 18 under trial prisoners in Bihar who had been jailed longer than the maximum possible sentences, it was she who took an initiative and filed PIL in this court. The single act of her led to the release of over 40,000 under trial prisoners nationwide, proving that one person commitment to constitutional values can unlock doors that have remained closed for decades. These efforts demonstrated that systemic changes begins with individual courage and collective action, proving that the finest victories come through conviction. The spirit of that drove Kapila Hingurani's pioneering PIL continues to inspire even today members of the bar when we are witnessing gradual yet meaningful evolution in how the legal profession approaches these challenges. Every day some very meaningful and very important issues are being raised through PIL platform, that all credit goes to members of the bar. The bar has begun embracing legal aid work with renewed vigor, with advocates increasingly recognizing this as their professional duty rather than optional charity. The increased participation of dynamic young lawyers in the Supreme Court Legal Service Committee to represent cases of indigent litigants stands as a shining example of this goal. And briefly explained, pointed out by Pragya, when before taking over NALSA, when I was looking after the Supreme Court Legal Service Committee, at that time also I took one initiative, and thanks to a very dedicated team of officers, we tried to find out throughout the country that how many convicts are there who have never had any access to Supreme Court, though whatever may be the fate of the litigation, their matters could be eventually examined at the highest court level also. So in that process we found out there are more than 44,650 something convicts, or all of them, or some under trials who had already undergone, they were convicts, all 4,652 were the convicts, under trials were separate. So what had happened is that these convicts, either they, after the High Court decision, they never came to Supreme Court, or their appeals were still pending in the High Court, and more than half of the sentence they have undergone, but they are not released on bail. And third were those who had already undergone the minimum of the sentence, and their case claims for premature release, remission or parole could be considered. So having divided into these three categories, we started pressurizing the state legal service authorities to send forward these cases immediately for filing. And I recollect, and I know most of them are present here. So when I requested the legal aid counsels to attend a meeting, believe me, all of them are here. When I said that I want all these cases to be filed by so and so cut-off date, and I want to certify that all these matters have been filed in Supreme Court, except barring they pointed out that these are the only procedural impediment or difficulty that we are experiencing, each one of them wholeheartedly came forward. They never let me down, and I felt proud when I came to know that 6, 7, 8 matters given to one counsel were prepared, drafted and filed in Supreme Court. That is the enthusiasm, that is the commitment, that is the dedication, that is the passion the members of the bar have for legal aid matters. And that was in fact one of the initiatives that really emboldened me, or really encouraged me, that on the NALSA platform, which is of course a pan-India platform, I will try to take some larger and some bigger initiatives for providing the legal, to give the more strength and a kind of a better visible existence of the legal aid mechanism in this country. What moved me really deeply was as I said, the advocates from across the spectrum, they came forward And it was their collective dedication to whom I must attribute that entire success, not to this Supreme Court Legal Service Committee or any other platform. But we need more. We need courage to innovate, wisdom to collaborate, and determination to succeed. In this vein, I invite even senior members of the Supreme Court Bar to consider taking maybe 2-3 additional matters each month pro bono on behalf of the Supreme Court Legal Aid Committee, or those matters which are referred by the state legal service authorities for the purpose of free legal aid here. With that kind of a little more, I know that all senior advocates have offered, and their unconditional, commitment is there from all senior members of the bar, that they are ready and willing to take up the free legal aid matters pro bono. But sometimes I have seen that on the part of the establishment also, there is lack of initiative to contact. In fact, there are sometimes most very contentious matters where our office should reach out to these senior advocates and request them to come forward and to assist those persons who are in need of the legal aid. We need to maybe strengthen this mechanism, internal mechanism, a little more better. But I know the proactive approach of the senior members of the bar and an effective timely action on the part of the establishment of the Supreme Court Legal Committee and this NALSA, that will really collaborate an ideal situation where the quest for legal justice, the legal aid, is, it is immensely satisfied to the satisfaction of those who never can thought of engaging those senior counsel in Supreme Court. Pendency is a challenge which Mr. Vikas Singh hinted that there may be some matters. But then for pendency, I would say pendency is a very positive signal also. Why? I will give you one example, and this is how I have been evaluating it. In 1950s and after 50s, when up to 1956, probably Chandigarh is the only city post-independence developed as a regulated, well-planned city is known. And at that time when the High Court building was constructed, the town planner, the architects, all stakeholders, they thought of constructing a High Court comprising one Chief Justice and 7 judges. So the original building, which is now UNESCO declared heritage building, is comprising of one Chief Justice and 7 courts. But mind you, the strength of the High Court today is 85. So what has happened? The original building, then an ad hoc expansion, then another ad hoc expansion, then another ad hoc expansion. So what does it show? The amount of faith and trust the people have in the justice delivery system. At that time, nobody thought that people will be able to afford, or the people will become so aware, wise enough, and they will be sensitized about their rights and to come to the judicial forms for seeking redressal of their grievances. So the pendency is one, that positive aspect. But we face a sobering reality. Even the most robust legal aid framework loses its meaning, as you know, when justice arrives too late. This volume represents millions of citizens awaiting judicial determination, and for them, delayed justice often becomes denied justice. It reflects our collective responsibility to ensure that constitutional guarantees of accessible justice are not just available on paper, but delivered within reasonable time. The question we must ask ourselves is, what drives this accumulation of cases? Reasons are multiple, and all stakeholders need to sit together and identify those reasons. Both bar and bench, despite finest intentions, we have developed some practice, procedural parts, pendency of listing of so many cases, every case taking a reasonable time, If there is a lengthy matter, that takes the entire day, rest of the matters again keep on waiting in queue. These are all practical challenges which every day the bar and bench we all face. The infrastructure, the judge population ratio, there will be several factors. While we judges, I am talking about, if you, let me just, out of slightly context of this topic, but I just explain, the pendency now in district courts is not alarming. It's not very alarming because the district courts level, in most of the states, the cadre strength have increased, the officers have also been timely recruited, and somehow or the other the system has expedited. Unfortunately, what's happening is that the High Court level, the matters are really stuck, whether it's criminal appeals or civil appeals. In civil appeals, in some of the High Courts, very pitiable condition. And so is in some of the High Courts, like Allahabad High Court, the criminal appeals are awaiting from last more than 2 decades of their turn to come. Reasons are varying for reason to reason also, from one High Court to another also. But my concern slightly, which of course has a very, in a very most humble way, I will try to convey to the High Court judges is that some of them are performing outstandingly. If you see the way they are prepared, they sit in the morning and by the evening, the amount of disposal they give, the kind of quality hearing they give, the quality judgment they deliver. But some of the judges are still underperformed. To my mind, they have the capacity and capability to deliver the best. They need to really ask one question to themselves before they go to bed and rest on a pillow, that have I repaid to the system, that system which has spent how much amount on me on a day? I think that realization among the members of the higher judiciary and a corresponding realization among the members of the bar that I must go and deliver best of the services, professional assistance to the court, if that ideal collaboration between the two can expedite the disposal of the matters which are still in queue, even if there is no extraordinary addition to the infrastructural facilities as of now. When I consider the concrete solution to this challenge, what we will look for? Why are all these things I have pointed out? That there are areas, there is a pendency, there is a need of timely justice, and there is a delay in justice. So then what should we do? Honorable the Chief Justice pointed out the alternative dispute resolution mechanism. I have already said that I will not use the word alternative, because alternative is something that you have to first go for the conventional system, and when the conventional system fail or there are some reason that you can't avail, then you will go to alternate. I am saying that let's have the parallel systems, and that parallel system is, the conventional system is one, mediation is also one of the parallel system, and thinking that mediation can really be the game changer in terms of addressing the issue of the pendency in courts, we have already launched a very promising initiative that you must have seen. It is captioned as the Mediation for Nation. It started on 1st July. It will end on 30th September. And it is a pleasant revealing before all of you that as of now, I am talking about as on 31st July 2025, that is within 1 month, the courts across India have identified more than 1.68 crores matters, cases, out of which they identified these cases, and out of which 5,12,468 cases have already been referred to mediation. I am not sure that up to now 19th or 20th August what is the position, but this is I am only talking about 1 month. But I am 101% sure that by 30th September when the deadline comes, there will be at least 25 to 30 lakhs pending cases in courts that will be referred to the mediation. So for mediators, it's going to be a big challenge. These are not ordinary matters. These are not merely motor accident claim cases or matrimonial disputes. These are all some of the contentious cases also. And all the tools, the equipments, the knowledge, the art of dealing with the situation, I think your entire talent will be at stake in dealing with those matters. And if you succeed in mediating in those matters, let me tell you that mediation will become, as I said, not only the game changer, it will become the most preferential mode of adjudication of the dispute. So, I must also share with you that somebody rightly pointed out to us that if you are having a nationwide call of mediation for the nation, where are so many mediators to tackle this situation? So simultaneously, in Supreme Court, our MCPC, we have started providing online training, and I can pleasantly share with you that the figure of trained mediators has also multiplied now in thousands. And our objective, for that also I have separately launched a program, that in every village, some neutral person, preferably who are retired teachers, retired employees of the social welfare department, or for those who were served as Anganwadi or other kind of departments. If these persons are available, we will train them as mediators so that in the village itself there is a group of trained mediators available as a part of access to justice at the doorstep. That scheme also we are separately launching. Now, in this entire effort, I can share one small instance because that will, this is how I got encouraged also. I was not even 38 when I became Advocate General of the state, and we had a dispute with a German bank of one of our power corporation. That dispute had arisen, and in terms of the agreement that had been referred to an international arbitration. So we had nominated a former Chief Justice from India, and the presiding judge was a former Chief Justice of the Singapore Supreme Court. When I took over, the file was put up before me, I found that crores of rupees have already been spent in litigation, in arbitration, and that was still at a very preliminary stage. The total amount in dispute was 167 crores, which the bank was claiming, the German bank was claiming, and our corporation was denying that claim. Anyway, I read the file, and my view was that we are going to lose this matter. The award will be, in all circumstances, passed against me. So I talked to the government, and in the cabinet they authorized me to negotiate with the German bank. So I, along with 3 or 4 officers, I went to Germany. Of course, I'm very briefly pointing out, I took help of Soli Sorabji, he was Attorney General, and we went to Frankfurt, and the meeting was organized. In 25 minutes, the managing director of the bank agreed to that you pay me the principal amount, we will forego the interest. Frankly speaking, I was not very fond of or a person who at that time would believe in mediation. But then I realized that even if 2 litigants can sit together and find out a via media and solve their problem, if there were a person who were to mediate between them, what an ideal situation will be there. So since that matter, and after of course couple of months then I was elevated, I realized that yes, mediation is a very potential tool to bring that win-win situation where both parties go with smile and both feel that nothing has been lost and they both feel that they have gained out of ultimately the settlement. One matter you will see in my court, probably every 2 weeks, 3 weeks I am taking up that matter. There are two brothers from Delhi and Kanpur. They have been fighting from last 37 years. So eventually I called them in court and I said, भाई क्यों किस बात पे लड़े जा रहे हो आप तुम्हारे? तो मैंने उनको थोड़ा सा sometimes I use my own way also. So मैंने उनको थोड़ा सा दिया कि आपको क्योंकि फादर की इतनी ज़्यादा प्रॉपर्टी है तो आप इसलिए आराम से यू कैन अफोर्ड लिटिगेशन, इसलिए आप कोर्ट्स के ऊपर बर्डन बने हुए हो. बोले नहीं जी नहीं ऐसा नहीं है, इसमें फॉल्ट है, इसमें फॉल्ट है. तो then I requested one of the mediator. I will send both of them. And after 37 years, they have settled the dispute. So mediation is an extraordinary potential tool. It's a resolution through dialogue. Today, when the corporate entities enter into any kind of agreement, whether it's international agreement or a domestic services, you provide a clause, dispute resolution clause. And dispute resolution clause, so and so will be arbitrator, so and so court will have jurisdiction, or so and so court will not have jurisdiction. My dream is completely different. When these two entities will enter into an agreement, they will have a clause of dialogue, not of dispute. And dialogue is when through mediation, the agreement itself should provide that in the event of any dispute, we will have a dialogue and we will have a mediator, so and so they can name also, and through mediator that we will resolve our dispute. We need to develop that culture at nationwide and maybe even on the international platforms. The members of the bar can play a very vital role in that regard. Let me share with you another experience. Last year or maybe in the land of 2023, I got an invite from the Malaysian Federal Court Bar Association, inviting me to deliver keynote address on the inaugural of their International Mediation Center. I told them that on Bar Association invite, I may or may not come. It all depends upon whether I will be permitted to attend. But meanwhile, then I got an invite from the Chief Justice of the Federal Court of Malaysia also, and then I went there. Believe me, the entire program was organized by the Bar Association of the Federal Court of Malaysia. It is they who took the entire initiative to establish the International Mediation Center, and for them, it was a big achievement because they wanted to attract the international mediation disputes. And through mediation platform for which they created the entire infrastructure in Kuala Lumpur. So the bar, when comes forth and takes this initiative and take the rather lead in establishing mediation institutions, my personal opinion is that effectivity, the outcome will be entirely different. It is going to be a successful story. And that is the expectation I have from the members of the bar here also. This is very encouraging. Why I say? Because when I get the report from the mediation center or from the nowadays from the MCPC, the maximum persons who are requesting for joining the mediation training online are the members of the bar. So that shows their faith, that shows their interest, that shows their keenness to be trained mediators and ultimately to serve the cause of mediation. So that itself is a very encouraging factor for all of us. I only believe that when we continue with this kind of culture, the mediation will become our culture, courts will become the last sanctuary of as a last resort and not the first response. They will be the last option. The first option will always be the mediation. And this shows that while mediation may not be a one-size-fits-all, because that has to be case to case and it will depend upon, but it can be tailored to each dispute's unique dimensions. So that flexibility in mediation is a very, very important factor to make it a very successful event. I would also, when I was talking about the mediation initiative that we have taken under the banner of the mediation for the nation, I have been appealing to all the bar associations, and that's appeal to, of course, before you also, that you need to kind of take a resolution, and that resolution will be that you love mediation. If that commitment comes from the bar, I am 100% sure that you will see in Supreme Court also and in High Courts also, the issue of pendency is effectively challenged. By 2030, I envision every district with a dedicated mediation center for which we will plan. Commercial contracts, as I said, starting with a dialogue clause, no dispute clause. I only imagine that a young startup in Bengaluru and a supplier in Bhopal resolving their payment dispute through a video call with a mediator, reaching agreement in 2 hours instead of 2 years. Imagine a farmer in Punjab and a bank in Mumbai finding common ground through conversation, preserving both the loan relationship and the farmer's dignity. This is not a kind of a utopian thinking, this is achievable reality because the bar and bench both are committed for this reality. Mediation represents far more than another dispute resolution mechanism. As I said, it offers the bar a genuine opportunity to reshape how ordinary Indians experience the law. In conclusion, I would say, and I am reminded rather, that justice, like a great river, finds its way through every landscape, sometimes carving through mountains of precedent, sometimes flowing gently through valleys of understanding. Legal aid and mediation are not separate streams, but they are tributaries that feed this eternal river. In Mahatma Gandhi's words, and I quote, "The best way to find yourself is to lose yourself in service of others." Today I ask the distinguished members of the bar to lose itself in service of justice itself. Law is not a monument to be admired from afar. It is a living garden that requires constant tending. Legal aid plants seeds of hope in barren ground. Mediation nurtures understanding, ever only as compared to what the conflict once grew. When we make justice accessible, when we choose dialogue over discord, we honor something sacred, the belief that every human voice deserves to be heard, every grievance merits attention, and every conflict contains within it the seed of resolution. Therefore, our legacy will not be measured by the cases we won, but by the bridges we build. Bridges between law and life, between power and compassion, between what is and what ought to be. Let us be the generation that proved justice is not a privilege to be purchased, but a promise to be kept. Thank you very much. Thank you for giving me this opportunity.
Thank you, sir. We are grateful for this wonderful lecture and sharing your vision with us. Sir, as a member of the bar, we have one more demand and a request for having physical mediation training in addition to online training by MCPC. I request Mr. Manish Dubey, Joint Secretary SCBA, to kindly give vote of thanks.
Honorable Mr. Justice Surya Kant, Judge Supreme Court of India, other honorable judges of the Supreme Court of India, Sri Vikas Singh, President, Sri Rahul Kaushik, Vice President, Sri Pragya Baghel, Honorary Secretary, SCBA, distinguished guests, members of the bar. It is both an honor and a privilege to stand before you today to deliver the vote of thanks on this significant occasion. The inauguration of our lecture series titled Justice for All, Legal Aid and Mediation, the collaborative role of bar and bench. The series is not just an academic initiative, it is a call to action. It reminds us that justice must not only be done, but must be made accessible, affordable, and compassionate. The collaboration between the bar and the bench is central to this mission, and today's event has beautifully set the tone for the conversation and commitment that will follow. I begin by expressing my heartfelt gratitude to Honorable Mr. Justice Surya, Judge Supreme Court of India, for delivering the inaugural lecture. Sir, your address was both enlightening and inspiring. You have beautifully articulated the importance of legal aid and mediation in strengthening our justice delivery system. Your emphasis on empathy, efficiency, and collaboration will surely guide the spirit of this entire series. Legal aid and mediation play a vital role in making justice truly inclusive. Legal aid ensures that even the most marginalized citizens have access to legal representation and protection under the law. Mediation, on the other hand, offers a peaceful, time-saving, and cost-effective way to resolve disputes, often preserving relationships and reducing the burden on the courts. Together, they represent a humane and progressive approach to justice, and their success depends on the active cooperation between the bar and the bench. We are deeply thankful to all the honorable judges, legal luminaries, senior advocates, and members of the bar who have joined us. I wish to thank Mr. Rakesh Khanna, former President, Mr. Jiten Mohan Sharma, former Vice President, Mr. Rohit Pandey, former Secretary, Mr. Anil Hudda, Mr. Ajay Bansal, Ms. Yugandhara Babar Jha, Mr. Vikas Bansal, Ms. Ritu Bharadwaj, Ms. Service Ren, Mr. B.S. Misra, former office bearer of SCBA. I wish to thank Sri Vipin Nair, President, Sri Amit Sharma, Vice President, and Mr. Nikhil Jain, Honorary Secretary, and other office bearer of SCORA. I also thank Ms. Nandini Gore, former Secretary, SCORA. I wish to thank Ms. Neena Gupta and Mr. Somajit Pani, member of GICC. My sincere thanks to all the mediators who are joined us. I extend my sincere thanks to London Secretary General, Sri S.C. Mugante, Mr. Kuntal Sharma Pathak, Registrar, and other registrars of the Supreme Court and the media persons. Please join us for high tea. At ceremonial hall at 3rd floor and ground floor for high tea. Kindly come on the dais for photo. Member Executive. I request all EC members, kindly come on.